أعوذ بالله الشيطان الرجيم بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. Now, in our lesson today, we shall be talking about the international criminal law. Remember, in our previous lessons, we were talking about the international humanitarian law, which is also known as the law of war or the law of armed conflicts. So we have finished with the first part of this course. So today we shall be starting with the other half of the course. So today we shall be having two lessons. So this will be the first part of our lesson. Now, these are going to be our lesson objectives. By the end of this lesson, you should be able to, number one, define international criminal law and explain its objectives and key characteristics. Number two, state the fundamental principles of international criminal law. Number three, explain the concept of individual criminal responsibility in international law. Then distinguish between direct perpetration, joint criminal enterprise, and aiding and abetting. Then describe the basis of superior stroke command responsibility. And lastly, identify and explain the major defenses available in international criminal law. So in brief, this is going to be the first part of our lesson. Now, as we start this lesson, we are going to start with some key definition. But before the key definition, we have the introduction. So international criminal law, because somebody can ask, what is international criminal law? So international criminal law is a body of public international law designed to prohibit and punish certain categories of conduct. That is, the core international crimes considered to be of grave concern to the international community as a whole. So, number one, what you are learning from this introduction is that the international criminal law is a branch of what? Public international law. And its main objective is to deter and to bring into accountability people who participate in international crimes. So it establishes individual criminal responsibility for these crimes as opposed to state responsibility. And this element is very important. So international criminal law, it looks for individuals who participated in international crimes. It does not go for the country. It does not go for the state. Now, to make even the matter very clear, here we have three definitions of international criminal law. So, number one, Antonio Cassese defines international criminal law, as the branch of international law that establishes individual criminal responsibility for serious violation of international norms, particularly those protecting fundamental values of the international community. Okay, number two, Joe Hardwell defines it as a system of legal rules that defines international crimes, determines individual criminal liability, and regulates the prosecution and punishment of perpetrators under international law. Then lastly, William defines it as a body of law that governs the criminal prosecution of individuals for crimes of international concern, including genocide, crimes against humanity, and war crimes, whether before international or national courts. Now, if we analyze these three definitions, you will realize one thing in common. That is, in all these definitions, we have the element of individual criminal responsibility, individual criminal liability, criminal prosecution of individuals. So what we learn is that the international criminal law, it focuses with individuals who have participated in international crimes. For example, genocide, crimes against humanity, war crimes, aggression, إلى غير ذلك. So this international law, it ensures that each and every person who participates in all these crimes, they are brought into books. That is, justice actually works, that each and every person is accountable for their action. So this is just basically the same thing they're trying to explain, that the international criminal law is a branch of law that deals with crimes of international concern, typically committed by individuals. So they're repeating the same element of individuals. So its purpose is to hold individuals personally accountable for crimes that shock the international community. Now, it focuses with these 4 crimes, and we shall cover these 4 crimes in the next lesson after this: genocide, war crimes, crimes against humanity, and aggression. So the key point here is that international criminal law, it focuses with individual responsibility and not state responsibility. Number 2, it ensures justice beyond national boundaries. So, for example, if somebody participates in atrocities or kill people, or and that person is in Somali. So if the courts in Somali, those are the domestic courts. If those courts are not going to deal with that person, then the international courts are going to deal with him. So it ensures justice beyond national boundaries. And it is complementary to domestic criminal law. So the international criminal law often intervenes when national systems fail. So when the domestic criminal law fails, then we can subscribe to the international criminal law. Now, what are the objectives of international criminal law? Number 1, al-muhasaba, accountability. Punish perpetrators of serious international crimes. Punish each and every person who participates in what? In international crimes. Number 2, deterrence. Deterrence means what? To prevent. When you are deterring something, it means you are preventing. So it is to do what? To prevent future crimes by establishing legal consequences. So it will prevent, because if people know there are some legal consequences for their action, then they are going to stop to do those things. Then justice for victims, recognize suffering and provide legal remedies. So those people who have been affected by the war or the crimes, at least they can do what? They can get the justice. Then to promotion of peace and security, strengthen international order, and prevent conflicts. There cannot be order if there are no laws that guides and governs. Development of legal norms. When you're talking about legal norms, al-adat, so clarify what constitutes serious crimes under international law. So it clarifies for us. So we can easily know if this is genocide or it is not genocide, or if it is a war crime or not a war crime. So the international what? The international criminal law will define that. Then end impunity. Prevent perpetrators from escaping justice. Impunity is when people, they escape justice, either by bribing the system or by using their connections. But if we have this law and it is being implemented fairly and squarely, then this impunity will not be there. Then lastly, establish historical record. That is to create authoritative legal account of events. So we can have a record of all the crimes and the perpetrators in a file. So it becomes very easy to do what? To refer to. Now, what are the key characteristics of international criminal law. What are the characteristics? Number one, individual criminal responsibility. Like we have been saying, it deals with individuals, not abstract entities like states are put on trial. So you cannot put a country on trial, but you put individuals from those countries on trial. Number two, international elements. So the international criminal law, it deals with crimes that affect international peace and security or are committed across borders. Then complementarity. When you're talking about complementarity, you can think about it as a takamul. So international court steps in only when national courts are unable or unwilling to prosecute. So we go internationally when there are some gaps domestically. Then universal concern, crimes are so serious that any state can exercise jurisdiction. So there is what is known as universal jurisdiction. So international criminal law basically means that that crime is very big. Even if you're in Somalia, if you go to Ethiopia, Kenya, Uganda, or any other country, you can still be taken you can still be accountable for those crimes. So it does not mean when you run from Somalia, you go and hide somewhere, that nothing is going to happen. Then no statutes of limitation. These crimes can be prosecuted no matter how much time has passed. So we are now in 2026, and even if these crimes happen, for example, in 2020 or 1998, it can still be investigated, and the people we can still bring those people to book. Like just in the case of Gaza, the Netanyahu, they've taken him to a court of the International Court of Justice. Why? Because of the genocide that is happening in Gaza. Yes, it happened in, for example, the past 2 years. The war started in 2023. So we cannot just say, we are now in 2025, so he cannot be accountable for what happened in 2023 or 2024. No. He still will be accountable. Now, what are some of the key principles of international criminal law? So, number one, it's still the same with the characteristics. Number one is legality. No one can be punished for an act that wasn't a crime at the time it was committed. This is very important. No one can be punished for an act that wasn't a crime at the time it was committed. Mathalan, for example, in 2025, maybe shooting, maybe it happens that you shot 100 people. But by that time, shooting was not a crime. In 2025, the International Criminal Court, they state that shooting from 2025 is a crime. So they cannot go back to 2020 and tell you that, in 2020, you shot 100 people, and so you cannot be accountable. Why? Because at that time, it was not a crime doing what you did. Number two, individual criminal responsibility. Like we have said, only individuals, not states or organizations, are prosecuted. Number three, command responsibility. Leaders may be held accountable for crimes committed by subordinates if they knew or should have done. Just like Netanyahu, he's a leader of a country. Now he's been taken to the court of International Criminal Court. Why? Because he's a leader and he was the one who was giving the order. So you as a leader, you can be taken even if you did not participate, but you knew of it. You made decisions related to the what? To the killings. Then complementarity, as we have already said, International courts act only when national courts fail. No immunity. This is what we also said. High-ranking official, e.g. heads of states, cannot claim immunity for serious crimes. So there is no immunity for genocide. No. There is no immunity for what? For aggression. There is no immunity for war crimes, even if you're the leader of a country. For example, what happened in Liberia? Taylor, he was prosecuted in the international court, and he was a president, you can imagine. So it does not mean if you're a prime minister, you cannot be taken, no. Then proportionality and fair trial. Punishment must fit the crime. So what you did should be muqabil of what. So the punishment should be what? Should be muqabil the crime. It should be balanced. Defendants are entitled to due process. Those people who have been taken to the international court, they also have their lawyers who are going to represent them. So there needs to be a fair trial before we come into conclusion. And these are still that's the same principle as this, so we don't have to repeat it again. Now, on to the next point. There is the principle of liability and defenses in international criminal law. So what is the meaning of these two things? So what is the meaning of liability? Liability, literally, lughatan, it means liability basically means you've done something that is wrong. You are liable. Or liability in accounting means you have some duyun, liability. So principle of liability, these are the legal rules that determine when, matter, and how, kaif, when and how an individual can be held criminally responsible for international crimes. So they establish who is liable. Is it the soldiers? Is it the leaders? So who? Man huwa al-mas'ul an al-qital? Man huwa al-mas'ul? Then for what type of conduct? What conduct did this person do? What did he do, mathalan? Did he kill? Did he shoot? What did he do? And under what circumstance? Under what circumstance? Mathalan, maybe was he defending himself? Was it self-defense? Or it was just ashwaiya? So the principle of liability determines all these things. And the liability can be direct or indirect or through command structures. Liability can be direct, like you are the one who was shooting. فأنت مسؤول because you directly participated. You are having the gun. Indirect, it's just for the leaders. The leaders are the ones who did what? The leaders are the one who gave the instructions. So indirectly, you are just involved. You are the leader. So you participated indirectly by giving then also through command structures. In military, you have the commanders that normally give the commands. So that is what is meant by liability. Okay, fil muqabil, we have defenses. So defenses means I have to defend yes, you are saying that I am liable, but when I go to a court of law, I have to defend myself. So legal arguments that a defendant can use to avoid or reduce criminal responsibility. So you can go to a court of law, you can avoid, maybe your lawyers, they can defend you and they can give evidence. Or through the evidence, it can reduce your criminal responsibility. So the lawyers are the ones who will always help you in this case. So they aim to negate the criminal intent. they aim to show that, hey, this guy did not participate in this criminal activity, you know, or it justifies the act that they did it, like Israel, the way they normally do it, which sometimes is very wrong, that they are defending themselves, the right to defend themselves. So sometimes it can be an argument that we were defending ourselves as a country or as an individual, or excuse the conduct under specific circumstance. Now, there are common defenses in international criminal law. We shall discuss more about this. So, in short, liability, rules that make a person accountable, muhasaba, what shows that you are responsible. And defenses, these are your arguments that can relieve or mitigate accountability. They can basically show, hey, this person did not participate in this crime, or he participated but not fully, partly. Now, another important thing is individual criminal responsibility, which is in the Article 25 of the Rome Statute. So every person can be held criminally responsible for their own actions or contributions to crime under international law. So your own actions or your contribution, because of your idea, you are contributing financially, you are contributing military, ila ghairi dhalik. So focus is on direct responsibility, not collective or state liability. Now, what are the forms of liability? Like I was explaining before, we have direct perpetration. So the person personally commits the crime. So that is direct perpetration. For example, shooting civilians directly or torturing prisoners. So here you are going to be directly accountable. Then number two, we have joint criminal enterprise. So this is a group liability for crimes committed as part of a common plan or purpose. And we have three types of joint criminal enterprise. We have the basic one, where all members share intent to commit the same crime. You have a member, for example, of 5, 10, the army, all of them, they have the intent to kill, the intent to cause aggression. Or systemic, these crimes are committed in organized systems. For example, putting people in concentration camps. You design specific places, you arrest people, you go and put them in those camps. Or there is the extended one, that is for foreseeable crimes by core members beyond original plan. Now, we also have aiding and abetting. So when you're talking of aiding and abetting, it is all about providing assistance. Like what is happening if we are actually using the international criminal law, all the countries that are supplying weapons to Israel, the Germany, the America, the world, under the international criminal law, they are responsible. They are partners in the crime. But does it happen? So when you provide assistance, you provide resources or encouragement to the principal perpetrator. How many people have supported Netanyahu, Mathalan? How many people? Oh, they have the right to defend themselves. They have the right to do this, this, and this. So there are many countries that are supporting genocide. So all of them, we need to take them to the court of law. Now, individual criminal responsibility. So according to the Article 25, there are different ways an individual can be responsible. Number one is soliciting or inducing. For example, persuading another to commit a crime that occurs. Maybe, example, politician incites mob to attack a minority group. For example, there is a politician is inciting people to attack a minority group. So that politician can be taken to a court of law, criminal law court. Why? Because he incited. You know, he was the one who said, he went to the media and said some words, and those words actually motivated the attack. Number two is aiding and abetting. This is practical assistance. You give funds, encouragement, or moral support that has a substantial effect on the crime. So underline this word, substantial. Maybe if the support is insignificant, then you cannot be taken to a court of law. So it has to be, the support needs to have a very big effect. Okay? For example, banker knowingly provides funds for militia, or driver transport troops to massacre site. So you are encouraging, you are assisting. Then there is the common purpose. This is the participation in criminal enterprise where crimes are foreseeable consequences of the plan. Look at the example. Member of criminal gang where violence escalates to murder. So it starts, you are a member of a criminal gang and you attack a group and violence escalates and people are killed. You being a member of that gang is enough evidence to take you to a court of law. Then perpetration, this is direct. Personally commits the crime through physical act, like a soldier shoots a victim. Then joint perpetration, essential contribution to a common plan with others. For example, general, minister, and commander jointly plan ethnic cleansing. People sit together, they plan. Indirect perpetration uses another person group as a tool to commit crime, must have control over the organ. For example, dictator uses secret police to carry out disappearance. So you are a dictator, you are using the police, they go, they attack, it's called abduction. They attack people, they go and arrest people, they kill them, they disappear. Ordering, person in authority orders commission of a crime that actually occurs. For example, commander orders subordinates to burn a village. So all these are forms of what? Individual criminal responsibility. Now, what about superior command responsibility? So the superiors, that is the military or civilian, can be held responsible for crimes committed by subordinates if certain conditions are met. Ahyanan, you are the leader of the military. You are the leader of the police. So sometimes you can be taken to a court of law under these three circumstances. Number one, superior subordinate relationship. Must have effective control over the subordinate. So number one, the court will determine you as a leader, were you effectively controlling the subordinates? Were they under you? Were they taking order directly from you? If that one is determined, then you have a case to answer. Number two, knowledge. You as a leader, there is the actual knowledge. Knew about the crimes. You knew. Ilman, al-ma'rifa bi al-madha, bi al-jara'im. So you knew about the crime, or constructive knowledge. Should have known due to circumstance. Even if you don't have actual knowledge, but based on the circumstance, based on what is happening, you ought to have known it. Okay? Then failure to act. Superior did not prevent the crime or failed to punish the perpetrators. So if you as the leader, You did not. That is exactly what is happening in Sudan. Like the Hameti, you know, he cannot prevent the crimes, yet he's the leader of the rapid support forces. So the rapid support forces, they're killing people and failing to punish the perpetrators. You know very well that members of the police, they're the ones who did an act of crime, but then again, you're just sleeping on your duty. So this is what you were just talking about the command superior responsibility. Now, what are the major defenses in international crime? So, under how can you defend yourself when you go to the International Court of Justice? How can you defend? How can your lawyer defend you? So, number one, mistake of fact. So, honest and reasonable belief that conduct was lawful. So, sometimes you can argue in a court of law that what you did, you believe 100% that it was the right thing to do. So honest and reasonable believe that conduct was lawful. So that is not a mistake of fact. Like, yeah, I just thought like 100% that what I was doing is right. Number two, mistake of law. That is generally not accepted. It is not accepted in the International Criminal Court. And this means ignorance of law is rarely a defense. No, I did not know. I'm very sorry, I did not know. You cannot go to the International Court and say, I did not know. That is not an argument. It's not accepted as a form of defense. Though sometimes some people will go and say, like, I did not know. Number three, self-defense. Protecting oneself from imminent threat. So you can say that I was defending myself. There was a very big threat. I had to use the gun. But then again, it must be proportional and necessary. For example, if you're defending yourself, then how did you kill 20 or 30 people? Because if you are defending yourself, you can kill 2, 3 people. But now you cannot claim that like Israel cannot claim they are defending themselves, yet they are killing thousands of people. That is not self-defense. Then duress or coercion. Committed crime due to immediate threat of death or serious harm. So sometimes you are forced to do something. They tell you, take this gun, shoot. If you don't shoot, we are going to kill you. So you can defend yourself and say, no, I was forced by them. I did not do it consciously. Then mental incapacity or insanity. So you can say, no, I lacked the mental capacity to understand actions, but it must meet a strict medical legal criteria. Somebody has to check to ensure that you are having some mental problems. Then superior orders. You can defend yourself and say, I was following orders from my superior. You can just say, I was just following orders. It was not me. So my leader has to answer the questions. Okay. So these are some of mental incapacity, intoxication. We did not. So intoxication, sometimes maybe you are using some drugs. You are under the influence of something, alcohol, drug, ila ghairi dhalik. So you can defend yourself in a court of law and say, you know what? I was under the influence of some drugs. So these are some of the arguments the lawyers they normally use to defend people. So of course they will defend them, and you know it can be the judges will determine if it is reasonable or unreasonable. And we have also explained this. Now, we also have the special note on immunity. So we have two types of immunity in international criminal courts. There is the functional immunity, the act of state. So no immunity for international crimes before international courts. Head of states can be tried. So there is, when you're talking of functional immunity, we are basically talking about al-wadhifa. And al-wadhifa can be, oh, I am the president, I am the minister, I am the ambassador. So even if you are the minister, even if you are the ambassador, even if you are the president, there is no immunity for international crimes. You are going to be taken to the court, the International Court of Justice. There is no immunity for that. Number two, so for example, there is the Charles Taylor was Liberia leader. He was taken, he was the president. And this Slobodan Milosevic, he was the president of Yugoslavia. He was the president, but still they were tried. Then we have the personal immunity. So sitting heads of state, diplomats have immunity from foreign national courts while in office, but not from international courts. So the personal immunity, we can provide immunity to heads of state, diplomats from foreign national courts. For example, the ambassador of Somalia in Kenya, you know, he has immunity. He cannot be tried in any courts in Kenya. But he does not have the immunity from the international world, from the International Court of Justice, you know? So you have to differentiate between this functional immunity and the personal immunity. Now, so to understand more about this lesson, you will follow this link, these links for more information. You'll get a lot of information. Just follow these links. So their lectures, they are basically explaining all the concepts we've covered. Now, so we're going to have a short break. So after 8 minutes, I'm going to send another link for the second lesson. So we are through with lesson 5. So after a few minutes, I'm going to send a link for the other lesson, because this Zoom is almost, it's going, I've already finished my free time. So I have to wait for another 8-9 minutes. Then after that, I will share another link. So please just be online, because I'm going to share the link for the second lesson. Okay, thank you.